An Anambra State High Court sitting in Onitsha has granted former Anambra State Governor and presidential candidate Peter Obi leave to serve court processes on actor-turned politician Kenneth Okonkwo through substituted means in a $5 billion defamatory lawsuit. The order followed an ex parte application after attempts to personally serve the legal documents on Okonkwo were unsuccessful. Take note of that and pay attention. Akahi News gathered that Justice D.A. Onyefulu directed the right of summons and other court documents be pasted at Okonkwo's last known residence in Onitsha, Enugu State, or delivered to any adult found in that residence. The court further ordered that the service be photographed and filed as proof of compliance within 7 days. The lawsuit stems from statements allegedly made by Okonkwo during a television interview, which Obi contends were defamatory. Okonkwo, however, has denied wrongdoing, insisting that his comments were based on complaints allegedly brought to him by aggrieved aspirants. What exactly has changed following this report? The court's decision does not determine whether either party is right or wrong. Rather, it ensures that the legal process can continue where personal service of court documents has proved unsuccessful. Pay attention. Substituted service is a recognized legal procedure designed to prevent litigation from being frustrated simply because a defendant cannot be personally reached. The case, nevertheless, carries broader political and democratic significance. Peter Obi and Kenneth Okonkwo were once political allies. Their public disagreement has now moved from the political arena into the courtroom, illustrating how internal dispute within political movement can evolve into legal battles. Please pay attention. Equally important is the issue of freedom of expression. Democracy thrives when public figures can criticize one another, expose alleged wrongdoing, and engage in robust debate. However, that freedom is not unlimited. Take note of that and please pay attention. Nigerian law also protects individuals against statements alleged to be false or damaging to their reputation, where a person believes such harm has occurred. The court provides a lawful avenue for redress. Take note of that and pay attention. At the same time, allegation of misconduct should neither be accepted as fact nor dismissed outright without evidence. The responsibility now rests with the court to examine the facts, hear both parties, and determine whether the statements complained of amount to actionable defamation or fall within legally protected speech. The substantial 5 billion naira damages sought have also drawn public attention. High-value defamation claims often provoke debate about whether they serve primarily to protect reputations or whether they may discourage vigorous political criticism. Ultimately, only the court can determine whether the relief sought is justified based on the evidence presented. This development also reinforces the importance of due process rather than resolving dispute through media exchange or political rhetoric. The parties have submitted themselves to judicial determination regardless of the eventual outcome. The integrity of the process will depend on fairness, transparency, and adherence to the rule of law. 5 things every Nigerian should know concerning this report. Number 1, the court has not ruled on the merit yet. It only approved an alternative method of serving court documents. Take note of that and pay attention. Number 2, defamation cases require evidence. The claimant must establish that the alleged statements were defamatory under the law. Take note of that. Number 3, freedom of expression has legal limits. Public debate is protected, but knowingly false or defamatory statement may attract civil liability. Gbese real. Number 4, substituted service is lawful. Courts may permit it when personal service cannot reasonably be effected. Number 5, the trial is still ahead. Both parties will have the opportunity to present their respective cases before any final judgment is reached. Listen and pay attention to this reflective question set for your deeper reflection. Number 1, how should Nigerian law balance freedom of speech with protection of individual reputation? Number 2, should political disagreements increasingly be resolved through the courts rather than public exchange? Number 3, what standard of evidence should be applied when serious allegations are made against public figures? Number 4, could high-value defamation claims discourage legitimate whistleblowing or political criticism? Number 5, how can political leaders maintain healthy disagreement without resorting to personal attacks? Number 6, what lessons should political parties learn from dispute among former alliances? Akahi News recommends the following based on this report. Number 1, both parties should allow the judicial process to proceed without undue public pressure. Number 2, political actors should ensure allegations are supported by verifiable evidence before making them public. That is very important. Number 3, citizens should avoid drawing conclusions until the court hears the substantive cases. Very, very important. Number 4, the judiciary should continue handling politically sensitive matters with transparency and impartiality. Very important. 5, media practitioners should distinguish clearly between allegations and established facts in reporting the disputes. And lastly, political organizations should strengthen internal dispute resolution mechanisms to reduce avoidable public conflicts. Thank you for joining me on this news analysis segment. Please, before I conclude this analysis, I want to quickly intimate you that intensive tutorial for 2026 OAU Post-UTME, OAU Pre-Degree, OAU JUPEP, and OAU School of Nursing is currently in progress at Akahi Tutors in Ile-Ife. Akahi Tutors is located at number 67 Ududua College Road off Sabo Junction, Ile-Ife. You can contact the management of Akahi Tutors on 08038644328. Thank you.